Welcome everyone to the Tonkin Legal Group, home of the Australian Family Law Podcast, the AFLP, definitely not the official podcast of the Australian Football League. This could also potentially be the new mug club. We're all repping our gear with the Timmy in the middle there. Hope you're all having a wonderful session. Sinjin, doing well?
I'm doing well, thanks, Joe. I thought you were going to say the Mug Club being the Essendon supporters, but but a big game coming up this week. Dreamtime at the G. Looking forward to it. Battle for the Spoon.
Spoon time. That's right.
Spoon time.
It's
Bit of early banter between the boys ahead of the game.
It's a battle between the unavailable and the incapable. Who is going to lose?
Who's who in the zoo in that case? Yeah, I had an email today where someone suggested we might struggle to field a team, but I say beware the wounded tiger.
He'll be listening to this as well, Andrew.
I'm sure he will. Andrew, g'day.
I am bewared. I beware a lot at the moment. This is the definition of a banana peel. Meanwhile, Charlie over there is sitting quite content and smug, some might say.
Grinning like a Cheshire cat.
I was going to use the word smug, Joe, but you got in ahead of me. Just trying to keep a lid on it at the moment over at the D's. So
the May champions, yeah.
The May champions, yep. A few good wins so far for us. So Hawthorn, Brisbane, Gold Coast. So knocking off a few teams at the top. So yep, no, it's going well, but yeah, it is. I'm very conscious of the fact that it is May. So just trying to keep a lid on it, but looking good, but also looking forward to watching both your teams go head to head on Friday night. Honestly, I think it's going to be. It could be a tight one, Joe. I'm sorry to say.
If it's anything like last year, one of the worst games I've ever. Thankfully, we won, but one of the worst games I've ever had to endure. But Charlie, I was talking to you last week, and we both thought Melbourne were a good chance to beat the Hawks.
Yep.
And you got them at a good time. No Gunston, no 3 or 4 other players were out.
Yeah, Nash. Yeah.
But you know the D's are playing a sustainable brand of footy. It's a final style footy, so anything could happen.
Yeah, well, you can only beat who's in front of you, as you know. So I think it would probably be a different story if they were full strength. It would have been a lot closer, obviously. But no, I think we're playing a good brand. So free and fast style. So speaking with Joe today or yesterday about how a change can do a lot at the top of the club. So no one was expecting us to be in this position this season. We could drop away at any point, knowing Melbourne, but it's looking good at the moment. So promising signs.
I like that you mentioned that.
Yeah, have you got much depth? Because you haven't got a lot of injuries, have you?
Yeah, that's a good point. I think we're probably 1 or 2 key injuries away from dropping, but yeah, so is a lot of clubs, to be fair. But yeah, I think if Gorney or Cozzy, touch wood, go down, then we could be in a bit of strife.
Although your new ruckman's doing all right. Your new ruckman's doing well, Charlie.
He is, yeah. Big Moose, Max Heath. I think.
No relation.
No. I didn't even think of that. Yeah, he's been good. He's getting a lot of game time, and they're playing the other Max going up forward a lot more. So, he's a good find from the Saints. And you're the Tigers, St John. You're 1 injury away from having to call up your VFL team for a player.
Yeah, some top-up players, which is a bit scary. We haven't been in this position before, but I know somebody who has.
That still gives me PTSD. Can we not talk about top-up, please?
What are the rules, though? I mean, not through the drug years, but when you've got no available players, you're allowed to pick 1 or 2 from your reserves, are you?
You're going to have to seek permission from the AFL, and the AFL
Yeah.
I think my understanding is that they have given that permission to Richmond to be able to basically contract one of their VFL players to
Yep.
be there as an to be listed as an emergency, because you need to have
Right.
23 playing players and then you
Mm.
need to have 3 listed as the emergency. Now you're cutting it really close with your AFL listed available players to be able to have those 3 emergencies. So that's how close we're cutting it. I don't think it's necessarily going to impact your performance on field any more than how you've been performing quite gallantly, if I might say, last week against the Saints. You definitely took it up to him. So
Yeah.
it will be interesting to see how it plays out on Friday night with spoon time at the G. But I guess we'll it's been almost 6 minutes of footy talk, and I'm glad that, Charlie, you mentioned that it's amazing what can happen when there's a change at the top. Obviously talking about King, but there was another change at the top in the competition, and it was with, of course, Josh Fraser taking over as the caretaker coach at the Carlton Blues. And lo and behold, they had their first coach, first game, first win right off the bat under the new regime. And so we're thinking, you know what? There's a new coach and there's a new relationship. Well, let's talk about some financial agreements between you people. So we're going to talk about the prenup, the during nup, and the post nup today. All of the nups, and
All the
you're going to
nups.
be
All the
absolutely sick
nups,
of
yeah.
it by the end of it.
Well, 2 things about Carlton. I tip them because everyone gets a bump when there's a new coach, a new lease on life for some reason. And I noticed in the paper today, Cripps has had one of the best games of his life every time a coach departs Carlton. So you got
Wow.
Malthouse, Teague, Bolton, and into Voss, wasn't it? And he had the game and a half after every coach has left. So, but he's been carrying Carlton for too long.
You need to
So
change coaches every week by the looks of things then for...
sounds like it, doesn't it? Yeah.
Yeah.
So get the best out of. In any event, a new coach or a new relationship. We often see people who have had an earlier relationship or marriage and they've separated, had their property settlement, sometimes a nasty battle through the court, and then they repartner. So this is where some financial agreements can become quite positive and the perfect scenario for people who are second time round, third time round, etc., etc. So you can have a prenup, which is an agreement that you enter into before you get married or before you begin a de facto relationship. It can be during the relationship, and it can be post the relationship. So what it really does is it just sets out how you're going to distribute your assets with your new partner in the event that you separate. So avoid going to court. There's a process and a plan that kicks into action if you separate. They're all legally binding and just as expensive as obtaining court orders without the battle.
And I guess it's a way of, we refer to it as contracting out of the Family Law Act. So in a sense, you're agreeing to not be, I guess, determined or administered by the relevant legislation, which is the Family Law Act. So you're agreeing to something away from that. And like St. John said, it's most common with parties who are in a second marriage or a second long-term relationship, particularly where either you or your partner are bringing in substantial assets from that prior relationship. Also very common where it's a blended family situation. So both parties have children from existing or prior relationships, and they're trying to preserve those existing assets to be eventually handed down to those children by way of inheritance. So they're probably the most common scenarios that we see for clients interested in prenups. Joe, did you have any other examples or types where those might be relevant?
Well, definitely wanted to add in relation to what you were saying in terms of contracting out of the Family Law Act, because I guess the really big idea, I suppose, and message to take out of that is because whenever you're going through a property settlement through the Family Law Act, you need to reach an outcome that is just and equitable. And by contracting out of that and having what is essentially a private agreement between you and the other party, potentially a new partner or someone who you're about to separate from, both of you will require to have your own independent legal advice because unlike, for example, the formalizing your settlement via the court with a consent order where there is an actual judicial officer there in the court to review your agreement and to determine, yes, this is indeed just and equitable, you don't have that in a financial agreement where you are contracting out of the Family Law Act and where it's privately organized. So without that oversight, both of you are required to go and get your own independent legal advice, and it's not optional. There's a statement at the end of the agreement where you essentially are signing, yes, I received independent legal advice from X lawyer, and the lawyer themselves have to also sign to say, yes, I gave the advice to this party. So there is an extra step there. Yes, it's entirely private, but you do need to make sure that you do get your own independent legal advice there.
Yeah, I think that's a good point. It's a private agreement, but it gives you flexibility. So it allows you to, as Charlie mentioned, contract outside of the Family Law Act. So you're not constrained by the Family Law Act. You can come up with your own agreement. It doesn't need to pass the scrutiny of the court, and you can control your own outcomes. And obviously, when we're advising clients, we wouldn't allow a client to sign an agreement that we thought was unreasonable or unfair. But ultimately, people are free to enter into uneven bargains. So at the end of the day, I think they're a flexible document. There have been a few issues recently with prenuptials and the later arrival of children, but we can perhaps discuss that in a different podcast. But technically, they're legally binding, allow you to have some control over your outcome. You're not at the behest of the court or a judge, and they can be implemented and have the full protection of the law.
Yeah, and I think in addition to what you mentioned, Joe, how both parties obviously need to have independent legal advice. Obviously, there's a number of other requirements. Both parties need to enter into the agreement voluntarily, free from any duress or coercion. That they're grounds to potentially have the agreement set aside at a later date. It's generally recommended that both parties exchange full financial disclosure beforehand. So both parties have that obligation to provide full and frank disclosure, and any party who might leave out certain information from the financial agreement, which is integral to the other party entering into that agreement, then that again might be another ground for the prenuptial or the postnuptial agreement to be set aside at a later date. So they need to be executed properly, and there's a number of requirements that need to be ticked off.
Yeah.
And I think they also give you the greatest protection allegedly against a future spousal maintenance claim. So if there's an imbalance in terms of incomes between the respective parties, then that might... Did I steal your show there, Joe? Were you going to mention that?
No, it just feels good to know that the principal lawyer and I are on the same wavelength. So that's keep going. Just keep going. Yes.
Yeah. So allegedly, it gives you the greater legal protection against a future claim for spousal maintenance, which just is money that one spouse seeks from the other to help them with their living expenses, and you can eliminate that perhaps more readily with a financial agreement as opposed to a court order. So that I think they're multifaceted. They have some flexibility, and they arguably, in certain cases, provide for greater legal protection than a consent order or proceeding through the court process.
Well, God forbid a deed, just a gift, for example. A lot of situations might involve, a signing of a wrong document rather than, for example, a binding financial agreement, which in the moment you feel like, all right, this has covered my bases and I'll be safe into the future. But then you'll come back, 20 years down the track, for example, and realize after speaking to a family lawyer, look, I've got this document signed, but it's like, unfortunately, if this was in the form of a BFA, you wouldn't be having this discussion right now. So ultimately, I think the key takeaway for our wonderful listeners out there is please get legal advice early from a family lawyer who obviously this is what we do for a living. So get that advice early, disclose everything. If nothing is set in stone at the moment, allow some time for negotiations. We can help facilitate that. You can do it yourselves and come, or alternatively, you can do it yourselves and come to us. But ultimately, I think it's definitely best for you to get in contact with your family lawyer sooner rather than later to make sure that the agreement that you do reach is indeed then set in stone and solidified so that it doesn't come to bite you 15, 20 years into the future when you think I'm all sorted. So that's probably a real important takeaway, I reckon.
I think you're right, Joe. And it's a relatively easy document to prepare, but it really depends on the complexity of the assets that the parties own. So if there are companies and trusts and self-managed super funds, then they can all be provided for, but a little bit more complex if you're adding different corporate entities and other vehicles that people use these days to build their wealth and to protect themselves. I think it also overflows into some estate planning areas too, doesn't it, Charlie and Joe, in terms of, you mentioned blended families. So these agreements can include third parties as well. So if mum and dad are lending a child some money, then mum and dad could be a part of the agreement and have their rights protected. As Joe mentioned before, sometimes people sign the back of a napkin saying, oh, this is our agreement, and when the proverbial hits the fan, that agreement isn't legally binding. And you're not protected, or you're vulnerable to a future attack. So see a family lawyer, do it properly.
Let's hope the proverbial hits the fan at the Essendon Football Club sooner rather than later, so that we can get Brad out of there and hopefully a nice clean sweep with the coaching staff. It's not all on Brad. It's not all on Brad, obviously. The issues were there pre-Brad as well, but geez, we'd love some fresh air at the club right now, wouldn't we?
So who have you got? You've got the Tigers, which you probably beat us. You've got West Coast.
Yeah.
And you've got Carlton. So
yep.
That could be three wins in a row.
And then Charlie's boys.
And then the
MCG.
Not at Adelaide Oval, thank God.
You ruined the D's season by that stage. That might tip them out of the 8.
Well, they flogged us earlier this season, but it was at Adelaide Oval. So, I don't know. I think if we're doing our tips for Friday night, which I might just throw in here now, I'm going to say Essendon by 3 points.
Bombers by 18.
Tigers by 9.
Are you saying that out of your desire for Mr. Scott to be removed from paid employment at the Bombers?
Thank you all so much for joining us today for episode 12 of the Australian Family Law Podcast, the AFLP. Definitely not the official podcast of the AFL. If you enjoyed what you had to see or hear from us today, please like, subscribe, hit the notification bell to not miss out on any of our episodes. And if you're listening to us on Spotify, please rate us 5 stars. All of these things, they're small, they're free, but it certainly goes a long way to helping our outreach to get more of this information to the general public, and we look forward to seeing you all in the next episode. Sinj and Charlie, thank you once again.
Go Tigers.
Go Scotty.
What?